Everyone, so beginning with rules relating to interstate succession of a Hindu male. So there are four categories: class 1, class 2, agnates and cognates. Class 1 heirs are the most preferred heirs, which include mother, wife, son, daughter, and their descendants up to the third generation, which means there will be a chart something like mother, wife, son, right? Mother, wife, son, daughter. So these are the basic immediate uh, relatives related by blood, you can say. So if there is a person P, his mother, okay, his wife, his son and daughter. So when there is another generation, we draw it below. Okay, so the preceding generation of P we draw above, the succeeding generation of B we draw below it. So this is first generation of mother, this is second generation, and son and daughter third generation. Fine. And their descendants up to the third generation. That means his descendants, that will be the fourth generation, or his sons, that will be the fifth generation. Fine. So these are class 1 heirs, descendants of these people up to the third generation. So if you count from here, this is first generation, this is second generation, and this is third generation, right? So this is class 1 heirs ka chart. Then class 2 include father, brother, sister, children, maternal, paternal uncle, aunt, maternal and paternal grandfather, grandmother, etc. So that means there is a person P, okay, his father, mother, fine. So it means there is a person P, okay, his father, so a generation above, his brother, the same generation, sister, the same generation, their children means brother or sister के children, fine. Maternal uncle कौन होंगे? जो इनके mother के भाई बहन, right? Maternal uncle, maternal aunt, and paternal uncle, father के brother या sister, right? Paternal grandfather, paternal grandmother means इनके father, right? Or इनके father or mother, or इनके father or mother. This is how it will go. Now there is a difference. You may notice that in class 2 we have mother, but in class 1 we have mother, but in class 2 we have father. So that you have to remember that mother is given preference over the father of the person P. Fine. And since they are the most preferred heirs, so if in a chart there is class 1 heir also and class 2 heir also, so the first one will be preferred and second heirs will not get anything. That also means that they will only inherit in absence of the class 1 heirs. If there is no one out of these people, that is no one in class 1 heir, then only the property will go to the class 2. And if no one in class 1 or 2, then it goes to agnates, and if no one in agnates, then it goes to cognates. So that is how it goes. Fine. So that is why it is a preferential chart. It is a preferential chart which goes from 1 2 3 4 heirs. Okay, so this agnate is the third class which I said, and cognates is the fourth class. Okay, so that's how it goes. Agnates, when two persons are related by blood or adoption wholly through males. That means over here it is written, see, P, his son, his son, his son, his son. So they are all connected by the line of male generations. Only sons, no female is coming in between them. So no female is breaking that chart. Fine. So they are wholly connected by males. Who is this? The son of P. Who is this? Grandson of P. Great grandson of P. Or if you go the other ways around, then if I look to P, S1, S2, fine, then he is grandfather, he is father, he is son, isn't it? So that's how the generations have gone. If I draw S3 also, then he is son, he is father, he is grandfather, he will be great grandfather, right? So that's how you can go and the generations will continue. I hope it is clear. Basic generation वाली बात है. And what I am saying as S1, S2, S3, in books generally this terminology is used. S का बेटा, S का बेटा है तो SS, SS का बेटा तो SSS, SSS का बेटा SSSS. ठीक है, it can be SSSS also. And if there are two sons of SSS, so you can write SSSS, SSSS1. So that's how it goes. That is the nomenclature when you draw that chart. Otherwise S1, S2, S3, the way I told you, that can also work. But since it is written in your book this format, if you follow that, it will be beneficial, because maybe teachers only find this correct and they may not correct the one that I have told you. So it depends upon teachers. Otherwise that's fine. Cognates, two persons are related by blood or adoption but not wholly through males, but they are connected wholly through females. Okay, so even if you not write not wholly through males, you write down wholly through females. So that are cognates. That means F here means female. That means if I write a person P, daughter, daughter, daughter. Okay, so again that will be daughter, then mother, grandmother, great grandmother, isn't it? So that's how the chart will go. Fine. And as I told you, adoption in the last chapter only, adopted child gets the same rights as the biological child. So that's why it is written either connected by biological birth, that is by blood relation, or by adoption. Either ways it can go, because the child is considered to be the member of the family and as if the real child, and he gets all the rights as the biological son would have got in that family. Okay, and since the date of adoption, he is considered to be the actual child of that couple. Rules of interstate succession of a Hindu female. If a Hindu female dies interstate, then heirs are divided into 5 categories. So the above one which we talked about, class 4 heirs, those were of a Hindu male. Now Hindu female, in which heirs are divided into 5 categories. Then here also the preferential list goes on. The first category includes husband, son, daughter, children of a predeceased son and daughter. So that means predeceased means died before. Deceased means recently died, and pre means before that. So if here, who is the deceased? We are talking about a deceased Hindu female who has died without making a will, right? So उनके पहले मरा हुआ बेटा, ठीक है. सो दैट मीन्स कि इस फीमेल की डेथ के पहले उनका बेटा ऑलरेडी मर चुका था. इन द लाइफ ऑफ दैट फीमेल हर सन हैड डाइड. तभी तो हम कहेंगे कि उनकी मौत के पहले उनका बेटा मर चुका था, राइट. आई होप देयर इज नो कन्फ्यूजन इन दिस वट एवर आई हैव सेड. So if I draw the chart for this first category, it will be, there is a female F. Now here F is not for father but for female, or you can say person P only. Let's take, there is a person P and this person is female. Fine. Husband, son, daughter, and there is also one son, S1, S2 I will do. Okay, and this son was predeceased. So predeceased पे हम ऐसे brackets लगा देते हैं, square brackets. It shows that this person died before the death of this person, जिसकी property devolve करवाने के लिए हम अभी बात कर रहे हैं, ठीक है. एंड इसके कुछ बच्चे होंगे तो उनको भी शेयर जाएगा. क्यों? क्योंकि अगर ये S2 अलाइव होता तो इसको शेयर मिल जाता, as these two will get. But since he is not alive, he had died before the death of female, तो उसके बच्चों को जाएगा. So that's why children of predeceased son and daughter. So if there is one more daughter who is predeceased, then उसके भी बच्चों को जाएगा. So that is the chart. Fine. The second category includes heirs of the husband. That can be, of course, the children of husband. Heirs of husband can also include all these people, एग्नेट्स, कॉग्नेट्स, क्लास वन, क्लास टू. ठीक है, इसलिए पहले प्रेफरेंस फीमेल के इमीडिएट एयर्स को मिली है, हस्बैंड, सन, डॉटर, चिल्ड्रन, बिकॉज इफ दे आर नॉट प्रेजेंट देन वो हस्बैंड के एयर्स को चला जाएगा, जो कि इन रिलेशन टू दैट फीमेल वुड बी हर इन लॉस, राइट. फादर एंड मदर फॉल अंडर द थर्ड कैटेगरी. सो दिस इज लिटिल डिबेटेबल और कंट्रोवर्शियल कि हस्बैंड के एयर्स को पहले मिलेगा और फादर एंड मदर ऑफ दैट फीमेल दे विल गेट लेटर ऑन, राइट. सो आई मीन जिसके बेटी की प्रॉपर्टी है उसको मिलना चाहिए, बट दैट्स नॉट द केस. Then heirs of father and mother are covered under fourth and fifth category. That means heirs of father is in the fourth category and heirs of mother are under the fifth category. So heirs of father can be the other children of the father of that फीमेल. दैट मीन्स उस फीमेल के भाई बहन और उनके बच्चे हो सकते हैं, बिकॉज वही तो उसके फादर के एयर्स होंगे. देन रूल्स ऑफ इंटरस्टेट सक्सेशन अमंग मुस्लिम्स. No codified law for that purpose. They are governed by religious texts. Among Sunni Muslims, heirs are divided into three categories. Sharers, Quranic heirs, residuaries, agnetic heirs, and distant kindred, that is uterine heirs. Kindred means, kin means family, distant means jo dur ke ho. Sharers are the most preferred heirs. They are allotted their Quranic shares, means whatever is written in their religious text, that is the Holy Quran, उसके हिसाब से उनको शेयर अलॉट कर दिए जाएंगे. If something is left after allotting shares to them, it goes to residuaries. If their shares exhaust the entire property, then sharers exclude residuaries and distant kindred. That means if first of all the sharers have to be allotted as per the Holy Quran, and if there is something left, suppose there was property of 5 crores, okay, and as per the Quranic shares they have to be awarded 2 crores somehow. I don't know the Holy Quran what is written in it, so I am just taking a very hypothetical example, so please excuse me for that if it goes anything wrong, but just to explain it I am taking this way. So if there is a 5 crore estate, out of which the sharers have to be allotted 2 crores as per the Quranic shares, okay, then 3 crore is left. So this left property will go to the residuaries, okay. But if the whole 5 crore has to be provided to them as per the Quranic shares, then that means they have exhausted the entire state. So now nothing will be given to residuaries and distant kindred because there is nothing left to be given, right. So ऐसा नहीं है कि जो next two categories है उनको देना ही देना है, but whatever is the shares, first of all किसको satisfy करना है, sharers को. When their dues or when their shares will be satisfied, allotted, then we will come on to the next two categories. And if the whole of the state is exhausted in allotting shares to the first category, then no need of going to the second one. ज़बरदस्ती नहीं है कि हम इनका कम करके इनको दे दें, ऐसा कुछ नहीं है, ठीक है. The distant kindred are not entitled to succeed so long as there is any heir belonging to class of sharers or residuaries. Means the kindred one, they will not get any share if the above two categories have some people in it and they will be entitled to get the shares, क्योंकि उन्हीं दोनों में वो चीज़ें या प्रॉपर्टी एग्जॉस्ट हो जाएगी. तो जब तक पहले वाले दोनों को नहीं मिल जाता, थर्ड की तो बात ही नहीं आती. So you can say that preferential list also goes on over here. But there is one case in which distant kindred will inherit with the sharer when there is only one sharer, that is wife or husband of the deceased, and no other sharer or residuary exists. Means there is one case in which the third category will inherit along with the first category. What is that case? जब एक ही sharer हो. That means only the spouse of the deceased and no other person in the first or second category exist. Only there is the spouse of the deceased. हो सकता है बच्चे नहीं हुए हो या फादर मदर भी मर गए हो उस टाइम पर. So only the spouse is living. So in that case, the third category will inherit along with the first category. Then Shia Muslims, heirs are divided into two categories: consanguinity, and by marriage, husband and wife. By marriage, there is only the spouse. Heirs by consanguinity further divided into three classes. Class 1, parents and children, that is the immediate generations, the immediate preceding and the immediate succeeding generation. The chart would be a person P, parents and children. Parents तो दो ही होंगे, father mother, children में जितने भी हों, and it goes for everyone whether it is a Hindu or a Muslim. Class 2, grandparent, brother, sister and their descendants. So chart जैसे पहले बनाया था वैसा ही है कि there is a person P, ये father mother होंगे तो इनके ग्रैंड पेरेंट्स होंगे, बिकॉज देयर इज नथिंग सेटिस्फाइड maternal, paternal, nothing of that sort is mentioned. So both ways, both sides. Then brother, sister, also brother, sister, the same generation, right? And descendants, so that means their children. Fine, this will be the chart. This is father, this is mother, and this is their father, mother. That will be grandparents concept. So we are not giving these two people the shares. These are not class 2. These are class 1 parents, right? These are class 1, and the children of this is also class 1, but the other ones that I have drawn in the same chart, they are class 2. Grandparents, these 4, then brother, sister and their children. Fine. Then class 3, paternal, maternal, uncles, aunts of deceased and parents, grandparents, etc. So there is one suggestion that I will give you at this point. Whatever chart I am drawing to explain you draw those charts separately. जैसे अभी मैंने एक ही चार्ट में क्लास 1 क्लास 2 दोनों आपको दिखाया, लेकिन आप दोनों का अलग अलग बनाओ, और चाहे तो अपनी बुक में जहाँ ये लिखा है उसके आगे बना लो छोटा छोटा, या फिर इन योर rough notebooks or any such legal notebook if you have made, you make these charts along with these headings, class 1, parents, children, and draw the chart below it. Take a person P and then denote these generations. That will help you for your further understanding. Okay, and put this heading also as by consanguinity and all these things, interstate succession. ऐसा आप ग्राफ और charts बना के रखो, that will help you. And in your exams, even if you don't write this way, no, class 1 includes this, if you don't write these in words and you draw the chart, that can also work, that can also be considered correct. There is no harm in that as far as I suppose, because either you write it or you draw it, the meaning should be inferred the same, just that you don't draw the wrong chart. Class 3, as I have told you, you can draw among the heirs by consanguinity, the first group excludes the second excludes the third. That means again preferential. If there is no one in the first group, then only we will go to the second group, and if there is no one in the second group also, that means first second दोनों में कोई नहीं है, तभी third group की बात आएगी. ठीक है. So if there are members in the first group, they will only be allotted the share, and second and third will be excluded. If there is no one in the first group, तो हम second group देखने जाएंगे, और second group को allot होगा तो third group रह जाएगा. That means they will not get any shares. So that's how the preferential list goes on. The claimants in both the categories, that is heirs by consanguinity, heirs by marriage, succeed together if there are heirs of both the categories. That means if there is a person P and his wife, इसके brother sister भी तो होंगे, इसके भी होंगे, तो both ways it can succeed, क्योंकि generation तो दोनों ही तरफ जाएंगी ना. Then rules of interstate succession under Indian Succession Act. Now Indian Succession Act is a central legislation, that means it is made by the or framed by the Union Legislature, right? Central government. So that is the central legislation which is applicable to all, unless governed by any law particularly applicable to them. That means the personal law or any codified law which is made like Hindu Succession Act. ठीक है. Act is not applicable to Hindus and Muslims. Christians and Parsis are governed by this. As I told you, if there is some special law which is applicable to them, particularly made for them, then they may be excluded from the purview of this act. Otherwise, this is a central legislation which has to be uniformly applicable on everybody. Then rules of interstate succession among Christians. Among Christians, the first preference is given to the spouse. And all the relations which we are talking about in this chapter relating to succession, they all are with reference to the deceased, जो अभी मरा है और जिसकी प्रॉपर्टी हमें बांटनी है. ठीक है, तो spouse of the deceased, lineal descendants, that is children, grandchildren, great grandchildren, or lineal descendants. So if I draw the chart of this again, there is a person P, spouse होगा इसका, आई एम टेकिंग ही इज अ मेल, ये फीमेल भी हो सकती है तो स्पाउस हस्बैंड हो जाएगा. राइट, ऐसा तो नहीं लिखा ना, वाइफ ऑफ द डिसीज्ड, nothing of that sort is written, so both ways it can go. Fine. So children, then children के बच्चे, ग्रैंड चिल्ड्रन, इनके भी जब बच्चे हो जाएंगे तो वो ग्रेट ग्रैंड चिल्ड्रन हो जाएगा. एंड व्हेन देयर अदर डिसेंडेंट्स गो, ऐसे ही और जनरेशन्स जाएंगी तो वो रिमोटर डिसेंडेंट्स बोली जा सकती हैं. सिंस इट इज गोइंग इन अ लाइन, सो दैट इज लीनियल. डिसेंडेंट मीन्स फर्दर जनरेशन्स. फाइन. सो चिल्ड्रन, ग्रैंड चिल्ड्रन, ग्रेट ग्रैंड चिल्ड्रन, दैट ऑल it can. Then no lineal descendants, then property passes on to spouse of deceased and those who are kindred, that is consanguinity is the connection or relation of persons from the same stock or common ancestor. So if there are no lineal descendants, children, grandchildren ये नहीं है, then the whole property will go to the spouse. So you can see the preference which is given to the spouse of the deceased. And then it will go to the kindred, that is consanguinity relation, which means that the people descended from the common ancestor, जैसे उसके father के और बच्चे, so that will be the common ancestor to him, right? So it will go to those people. And if there are no lineal descendants or kindred, then go to the spouse. So again the preference which is given to the spouse. In absence of spouse, now if there is no spouse, then property pass to lineal descendants or those who are kindred to him. So either ways there are only two categories of people जिसको क्रिश्चियंस में प्रॉपर्टी जा सकती है, या तो स्पाउस या फिर kindred. ठीक है. Rule of escheat. Rule of escheat is applicable to all the communities. So in the succession law for every community, first of all the property is given to the heirs which are provided as per the law, and if there is no heir present, okay, then the property goes to the government. So that is the last resort. If no one of the family, a relative or heir is present to whom the property could have evolved, right, then the property goes to whom? The government. That is the rule of escheat. Testamentary succession means where there is a will, right? The will is made by the person, and the person who has made that will is called testator, right? Then an executor under Muslim law is called a wasi, derived from wasihat, which means a will. A Muslim of sound mind and not minor, that is a major, can make a valid will. So what are the criteria and to be considered for a testator? That he would be of sound mind and a major, because then only he has the capability of deciding what are the best interests, and a major person can only deal with his or her property. A minor is not considered to be a person of capable mind who can deal or manage the property. That's why for those cases his legal guardian is appointed. Right, we did in the adoption chapter also that why guardians are appointed, so that of the minor's person, that is his body, and property if there is any, दोनों को मैनेज करने के लिए कोई इंसान चाहिए, because he as himself is not capable of doing that. So for the same reasons he cannot make a valid will. So anywhere, even for making or entering into a contract with another person, these are the basic requirements: sound mind and a major. Okay, so the wasihat means, you may have heard this term, wasihat बना के गए हैं. So that means a will, and जिसको मैं testator बोल रही हूँ, under Mohammedan law he is called wasi. No particular form is required, means there is no particular format that here should be the name of the person, here should be the account of property, the amount of property, okay, and what are the other properties, how will they devolve. Then you should write how you are devolving this particular property. Then put property number 2 heading, and then tell the devolution of that property. Then draw the table ki this property to this heir to this proportion, or make some chart or nothing of this sort, and at the last put your signature. So ऐसा कुछ भी format will के लिए नहीं दिया हुआ है, that for a will to be a valid will these are the formats or these are the requirements that you need to mention. ऐसा कुछ भी नहीं है. It's just that for a valid will sound mind और major की requirement होनी चाहिए. ठीक है, एंड दैट इज ऑल्सो इन द केस ऑफ हिंदूज एज वेल. फाइन, ये जो 2 रिक्वायरमेंट है वो हर रिलीजन में ऑलमोस्ट जाएगा. एनी unequivocal expression of a testamentary nature will suffix means that will go, that will work. And unequivocal means leaving no doubt or something which is clear. So that is the will which you are making, the contents of that will should be clear. Unambiguous means they should not cause any confusion when it is read, or only one meaning should be drawn from it. Unambiguous means कि 2 meaning नहीं निकलने. ठीक है, so suppose I write she was present there, okay, and the function was of the whole day, and she was required to be present the whole day also. So if I only mention she was present there, that means she was present the whole day, she was present for some duration, or she was present at a particular time, right? So nothing is clear. You can derive so many meanings from it. That means this expression carries ambiguity in itself, okay, and it can cause confusion. So ऐसा कुछ नहीं होना चाहिए. If I say she arrived Delhi in January, so on which date of January? That may be the middle, beginning, or end, or what. So that has to be certain. You should provide her this percent or this much of share that is sufficient for her living. So what is that share? कितना देना चाहिए, right? So इससे confusion हो सकता है. One person will say sufficient for my living is 50 lakhs. The other person will say no, 20 lakhs is enough for you. So that is ambiguous. To avoid such sort of disagreements or wars or fights or legal battles on the will, on execution of the will, it is important that whatever is written, that should be certain, clear, and unambiguous. It should not cause any confusion to the person who are executing it later on, because the person making the will has died. So there is no one who will confirm it कि हाँ मैंने यही लिखा था या मैं यही चाहता था. ऐसा तो नहीं हो पाएगा ना. So it has to be certain, which will work. So no particular format is required, just that it should be clear, and it can be either verbally or in writing. So it can be either ways, but of course if it is writing, then you have a proof of it कि हाँ देखो ये लिखा था. So it may help you at the time of execution. Otherwise what happens in the verbal communication, it passes on from one person to another, and there may be some modifications made by each person who is passing that thing, right? He may say something in his favor, the other person passing feels that okay, does not work in my favor, so he will make a modification. So that will not go as per what exact thing the testator or the passee person had in his mind. It may be forced to certain modifications by the people passing it over, right? So in that case, the written communication or the written will in any person or religious case, that will work better. Any property which is capable of being transferred and exists at the time of testator's death may be disposed of by a will. That means any property which can be transferred from some person to another. As we read before in one of the lecture, that there are 2 rights. One which can be inherited, and second which cannot be inherited, that is they die along with the death of the person, right? So property or the rights in it which die along with the person, of course they cannot be transferred. So something which is capable of being transferred and it is a present property, that means it was present or it existed at the time of testator's death. ट्रांसफर उसी चीज का तो वो लिख कर जाएगा ना. जो चीज़ उसके रहते थी उसके नाम पर, समथिंग विच इज इन फ्यूचर, हाउ विल एनी पर्सन प्रिडिक्ट द फ्यूचर? हाउ विल ही गेस दैट ओके दिस प्रॉपर्टी would come into my ownership on this date and I will be dying by that, so I will give the ownership of this property to this person? It's absurd, it's void, right? It cannot be enforced. So whatever you know at present, आप उसी का तो will बनाओगे at present जो आपकी ownership में है. So that means which is capable of being transferred and existing. Needless to say, property that belongs to another cannot be bequeathed by a will, cannot be passed by a will. So some property which is not mine, I cannot pass it over or I cannot write it in my will कि ये प्रॉपर्टी इस तरीके से ट्रांसफ़र करना, बिकॉज जब विल एग्जीक्यूशन की बात आएगी तो इट विल बी फाउंड आउट दैट ओनरशिप ऑफ दैट प्रॉपर्टी इज नॉट इन माई नेम. So I have no control of transferring it or selling it off or disposing it off as per my will. The owner of that property has all those rights. So on something which does not come under my rights, I don't have the power to exercise them as well. Fine. A Muslim can dispose of only 1/3 of his property, which is left after the payment of his funeral expenses and debts. The balance 2/3 goes to the heirs of the deceased. So 1/3 of his property can be disposed of, and first of all the payment has to be done from the property itself of the funeral expenses and the debts if there are any due on that property. I gave you an example of some debt on property in which the person has kept that property as a collateral while taking loan from the bank or any such financial institution capable of giving debts, right? I remember I had given you one example of that. So if there is some sort of debt like that in which the property was a collateral, so the amount of money of debt, that is the debt money, will be satisfied first from there, and then whatever is left, that can he dispose of, and the 2/3 which is left, that will go to the heirs of the deceased. So you see, we have done that in a Muslim, in Mohammedan law, only 1/3 of property can be disposed of as per the will of the person, right? And whatever is left then, that is the balance, that will go to the heirs of the deceased. That means heirs will inherit the balance property, and that is certain for them to inherit. The leftover 1/3 is used for the payment of funeral expenses and debts, and the payment of debts is something which is inheritable. So if after the satisfaction or after the selling of the 1/3 of property, if the debt is not satisfied, loan amount तब भी पूरी पे नहीं करी गई, ठीक है? That means suppose if the debt was of 5 crores but the property which was sold, that was only of 2 crores. Now 3 crores are still remaining which have to be satisfied. तो फिर वो 2/3 से लिया जा सकता है, because debt is something which passes on to the heirs. Fine. Testamentary succession among Hindus, Parsis, Christians, for which we have Indian Succession Act 1925. This is not the substantive law, such as what property may be transferred or what estates and interest may be created. So substantive law means some law or legislation which creates certain rights and obligations for the parties, okay? And having some property in your name, that means ownership right. So a right is being created. Yes. So if a property is transferred in your name, or some estate is owned by you, or some interest, that is again a right which is created in your name. That is what? The governing or creation of some rights and obligations. And every right has a corresponding duty, as I told you. So if you are buying some capital, buying some property, then what would be your corresponding duty? That you maintain it in a way that it not causes any nuisance or harm to the other surrounding people, surrounding or around that society, right? You do not do some act on your property which harms or which runs contrary to the fundamental right or to the dignity and living conditions of the other people, which may form their fundamental right. That means you basically cannot violate the other person's fundamental right. So that is your duty. Yes. So the Indian Succession Act will not tell you that what property shall be transferred what property shall not be transferred, and what kind of interests may be created. Okay, interest, see, right is nothing but a legally protected interest. So you can say that all rights are interests. Fine, because it is a legally protected interest. The Indian Succession Act deals with formalities related to execution. That is, if there is a valid will, then just making a valid will not do. You have to execute it, you have to perform that will. Execution means performance of that will. I have made some promise to you, but it is of no value unless I perform it. Right? If I have said that I will pay you 50 lakhs, so now you will wait for the performance, no? And performance of that promise means I am paying you that amount of money. So if there is a valid will which is made, okay, then execution of that means it is performed, and it means that whatever value or whatever amount or proportion of shares which were mentioned in the will to this or this person, they are actually given to those people. Then we will say that okay, the will has been performed. Fine. So execution means validation, means considering a legal document valid by performing all the necessary formalities. So you, what could be the necessary formalities? That when you discover a will written by an elder member of the family, you go to the court or the kacheri, and then you consider that whether it is a valid will or not. So all the necessary formalities and processes are carried out for that, and once it is found that okay, it is valid, then you execute it, you perform it, and give the concerned people their shares. Right? Revocation means revoke. It comes from revoke. Revoke means to withdraw. I have promised you something, but I withdraw my promise. That means now I will no longer be giving you that amount. So that is to withdraw or reverse the will. Revocation of the will means I am withdrawing the will, or I don't want, or somebody, like as I said, ho sakta hai that one son gets more of the share and the other son gets less the share as per the will. So he may want that the execution should be revoked. It should not be performed, and what should happen in the matter of justice at present is that both the sons should be awarded equal shares. हो सकता है ये, और इसी की लीगल बैटल्स होती हैं केसेस में, कोर्ट्स में. Revival means to revive. Revive means to restore. To use acceptance activity after a period of obscurity. Okay, to suppose it is dead or it is not being active for a certain period of time, then to restore it, that is revival. Interpretation means to find out the meaning of certain thing. Whatever I am doing right now, reading and explaining to you, that is what? Interpretation of your NCERT class 11 legal studies book. Fine. So interpretation is, and what I am doing is, while doing interpretation, according to my opinion, what meaning I could infer from the words or expressions or sentences written over here, I am just explaining to you that. So interpretation of anything is to derive the meaning of the expressions or sentences which are used over there from the language and combination of the words which are expressed over or mentioned over it. Fine. So I am also doing an interpretation of the book, as simple as that, and this could be the best example for you. So whatever I am telling you is according to my opinion or my application of mind of the expressions which are mentioned in your book, and some other teacher would tell you some other interpretation. So my and her interpretation can differ because we are different people, we have different minds, we are applying it differently, and we are giving a different interpretation of the book. A different meaning may be arrived. And if it is certain, if something is certain, तो क्या होगा, उसकी एक ही मीनिंग होगी और हर बंदा आपको उसकी एक यूनिफॉर्म मीनिंग ही बताएगा. I arrived in Delhi at 10:25 p.m. So what other meaning could be derived from this sentence? Nothing. एक ही तो मीनिंग है कि मैं इस समय दिल्ली में आ गई थी. Right? So if something is certain, there is only one meaning that can be derived. No room for ambiguity, no room for confusion. Right? So that is unequivocal. Fine. The grant of probate. The process of legally establishing validity of a will before a judicial authority. So probate means the validity of will को legally establish कर रहे हैं हम. That I am saying this is a valid will and I am proving it in front of a court of law. That means a judicial authority, that is judge or a judicial officer. Other legal representatives, powers, duties of executors, a person who is appointed by testator to execute the testator's will. So executor means the person who will execute, and we are talking about execution of what over here? Of the will, right? So executor is the person who is appointed by the testator. Testator ही appoint करके जाता है that after my death you will execute the will. You will grant the shares to these people. And you will ensure that whatever I have written, it is done in the same way. फाइन, उसका नाम भी कुछ लोग लिखकर जाते हैं. Administrators are persons authorized to manage an estate. Administrator is what? Administrator of anything, any event or any department. What is their function? To administer, right? To run it efficiently or to manage it, to control it. Fine. So here also administrators are authorized to manage an estate, that is a property, when the owner has died, intestate or without appointing executors. So if there is no mention of any executor in the will, then what will happen? Administrators are the persons who are conferred with that authority that now you will be managing the estate, and if there is some will, you have to manage it accordingly. Debts pay karo usme se, and whatever is left you pass it on to the heirs, and in the proportion of course which is mentioned in the will by the person. Fine. It is a secular law applicable to each and every community in matters of testamentary succession. Now there is a sample will which is given, like as I said, there is no particular format, but ऐसे बनाई जाती हैं generally. सब I, daughter, son of, resident of, aged this. See, ये तो जनरल क्रीडेंशियल्स हैं जो आप एक बेसिक एप्लीकेशन में भी अगर लिखते हो वहाँ पर आपको लिखना पड़ता है. दैट सन ऑफ, डॉटर ऑफ, रेसिडेंट ऑफ, एनरोलमेंट नंबर, वर्किंग इन दिस, स्टूडेंट ऑफ क्लास दिस, राइट, ऐसे लिखते हो. सो दैट इज़ अ वेरी बेसिक एग्जाम्पल which is given in your books. I, daughter, son of, resident of, aged this years, write my final will and testament. Why final? Because इसके बाद I will not get the chance of changing it. I may die. So that is my final, last and final. Any wills written previously are revoked. So if this is my final, that means this is my final decision, and all the earlier ones you consider it to be revoked and they will not be valid now. This is the only final and last, and this is only to be considered while you are granting the shares. Under the laws of India, I am writing this will freely and under no duress, means under no stress, under no pressure of anybody. I am writing this, but it is totally in my free and only my application of mind, in my free state of mind, in my जो साउंड माइंड की बात कर रहे थे वो इसी लाइन से प्रूव होता है. I am of sound mental, physical health and in a position to comprehend. Comprehend means to understand what I write in this will. So as I said, sound mind major का मतलब ही ये है that he is able to understand what consequences will follow out of his act or what is good and bad for him. I am married to this, have 2 children this. As of today, I own the following which I would like to bequeath by the virtue of this will. 1 this and cash amounting etc etc. So again you may see flat is an immovable property, right? Cash, Honda City car, Fortuner car, jewelry, all these are movable properties. Fine. So you can write the details of all your properties, whether movable or immovable. It is not necessary that only immovable properties have to be bequeathed or given or transferred to people by will. Movable also can be done. All the assets are self-acquired, means from his own skill, labor, money he has acquired those properties. Had it been acquired by the funds of joint family, तो वो joint family property बन जाता. No one less has any right, title, interest, demand whatsoever on these assets. That means apart from me, since it is self-acquired, I am the sole owner of that property and no one other has the right to claim on these properties. Since I am the only owner, so I have the sole right or responsibility to decide that how will I transfer and in what proportions. Fine. I have full absolute power, complete authority or in any other property which may be substituted in their place, which may be acquired or received by me hereafter. So if I purchase any other property which is again self acquired, तो वो भी इस लिस्ट में add on हो सकती हैं. ठीक है, and I have the absolute power on deciding that. It is my wish and desire that after my death, all my assets will devolve upon my wife. So, who shall then become? So, it is the wish of the person that he wants to devolve all those assets on his wife. And since it is transferred on the name of his wife, name has to be mentioned. So, she will be the sole and absolute owner after the death of this person. However, in the event my wife predeceases me, that means if she dies before me, then all my assets will devolve upon my children equally. Means all the children will get equal shares. 3 children, 1 by 3 to each. 2 children, 1 by 2 to each. Right? And forever to the exclusion of any other legal heir. Means forever till the time they are living, it will be to their children and no other person can claim it. Absolutely exclusion of any other legal heir means there may be some brothers, sisters, or my father and mother, but I'm not giving it to them. I'm absolutely giving to those people, and so no other person can claim it. Exclusively means I'm excluding all the other heirs. Only these particular people mentioned can be inheriting the property. So you see how certain and clear language it is written. Exclusion of all, exclusion of all, to make it certain that you cannot claim. I am the sole owner. I have absolute power. That is also written so clearly and certainly, right? So that is how your language should be certain, clear, unambiguous. Fine. All my loans and liabilities, not limited to taxes, penalties. Sex means charge on a charge, a tax on a tax, you can say, of whatsoever nature, whether existing or created after my death, shall be repaid and discharged by my wife or children as the case may be. So, whosoever is inheriting the assets, see, you have to inherit the good and bad of everything. Like it is said that if you are choosing somebody or if you are marrying somebody as your partner, then you cannot only take up his good habits, or you say that, okay, I'm not responsible for the bad things that you are doing. Or if somebody is praising your child, then there will be somebody who will say bad things about him or her. So you have to take the responsibility of both the things. There may be the two sides of a coin. So if the property is devolving upon you, that means you are gaining those assets. So along with them, whatever the charge or liability or debts are there due on the property, that also shifts on to the heirs. As I told you, it is a transferable right. So the liability is also shift, and now they are responsible for satisfying those debts which are due on the property. That's why it is written that whosoever will get the property, now they will also get the liabilities. I have made this will in full consciousness, without any pressure, coercion, undue influence, mistake, and with bona fide intent to avoid any dispute later on. And dispute कौन करेंगे? जो बच गए वही तो लड़ेंगे कि नहीं मेरा है, मुझे ज़्यादा, मुझे ज़्यादा. तो आई एम राइटिंग दिस इन साउंड माइंड विदाउट एनी अनड्यू इन्फ्लुएंस. क्योंकि बाद में क्या होता है, अगर किसी को कम मिले तो वो ये क्लेम करता है डू नॉट एग्जीक्यूट दिस विल बिकॉज वो इसके अनड्यू इन्फ्लुएंस में उन्होंने बना दी थी, तभी इसको ज़्यादा मिला है. बंदा तो यही सोचेगा ना, इसको ज़्यादा मिला है, ज़रूर इसने कुछ भड़का दिया होगा, कुछ ऐसा मेरे खिलाफ बोल दिया होगा कि उन्होंने मुझे कम दिया. बिकॉज मैं भी तो हूँ बेटा, जैसे वो बेटा, मैं से वो मैं हूँ. सो दीज काइंड्स ऑफ डिस्प्यूट्स में अराइज बिटवीन द लीगल एयर्स आफ्टर डेथ. सो टू अवॉइड दैट आई एम राइटिंग इट विद गुड इंटेंट. बोनाफाइड मीन्स गुड इंटेंट. Coercion, pressure means to coerce or to force somebody. I am putting a gun point, so that is coercion. Undue influence means, again, by love, affection, I am saying some things to you that you come into my favor and give more property to me and lesser to your other legal heir. Fine. Mistake means I was mistaken. I had been told that this person or this son will never come to you for your looking after or to deal with your property or to deal with your any such affairs. She will not come or he will not come ever. So that is a mistake of fact कि मुझे गलत बताया गया जबकि वो आ रहा था और मुझे बोल दिया कि वो नहीं आने वाला तुमको देखने. ठीक है. और मिस्टेक ऑफ लॉ, इन लॉ मुझे बताया गया डॉटर्स का तो कोई हिस्सा ही नहीं है, इसलिए मैंने सब सन्स को दे दिया. लेकिन डॉटर्स अब हिस्सा है, दे कैन ऑल्सो गेट, राइट. सो ये सारी चीज़ें हो सकती हैं मिस्टेक ऑफ फैक्ट और मिस्टेक ऑफ लॉ. I have carefully read and understood the contents, and the same is being signed. in presence of two responsible persons. Now, why these persons? Because they will be the witness. Those two responsible adult major witnesses, and they also should be of sound mind. And they, why witness? Because they are in the presence of them, the will is being written, and they will later on testify कि हाँ ये साउंड माइंड में था, कोई अनड्यू इन्फ्लुएंस, कोई प्रेशर उन पे किसी ने नहीं किया, और वो अपने आप से अपने डिसीजन लेकर उन्होंने ये चीज़ लिखवाई लॉयर से. I witness whereof have this to be my last will and set my hand on this day means date लिखी है. In the presence of under mentioned means these are the names and address or details of the witnesses, and they also have to sign in the presence of the testator. After the testator has signed, then witness जो है उनको भी sign करके अपनी details लिखनी होती हैं. ठीक है. So here this chapter is also completed. Thank you so much.